everybody, this is attorney Andy Marcantel with the Attorneys for Freedom Law Firm. And today, I want to talk to you about why it's so important in Arizona to call an attorney and retain an attorney immediately, first chance you get after you're arrested. I can't tell you how many times over the years and thousands of cases I've worked on where I've had somebody come into the office months after they've been arrested, maybe even years after they've been arrested, but before charges are brought, who miss so many great opportunities to prepare for the upcoming case and even to possibly avoid charges or minimize charges that are coming. This is so important, and it's the type of thing that as a defense attorney, I wish that I could have had the chance to talk to all of my clients before they came in. So in that spirit, I'm going to put it out there for you right now. Share this video. Make sure to consider all this. It's very, very important, and it's the best way to protect your rights under Arizona law when you suspect that a criminal charge might be coming at some time in the future. Okay, so you're arrested. Oftentimes, you don't get taken to jail right away. Maybe you get taken to jail, they fingerprint you, they DNA test you, and then they release you. Okay, this happens all the time. People are often told, okay, we're going to send this to the county attorney's office. They're going to take a look at it. Maybe they've got some testing to do. Maybe they've got some experts to consult. Maybe they have a victim of the crime that they want to discuss the case with before they bring the charges, and they just tell you, okay, just keep an eye on the mail. Here's your citation. Here's your paperwork out processing you from the jail. Keep an eye on your mailbox, and we will let you know in the future when you've been charged with a crime. This happens all of the time. Another thing that happens is sometimes they'll arrest you, they'll take you to jail, they'll put you in front of a judge for something called an initial appearance, which, by the way, under Arizona law, they're required to do within 24 hours of you going into custody. And then they do something called scratch your case. What does scratch your case mean? It means temporarily dismiss your case. They say, all right, sir, we've got some additional investigation to do before we proceed with the charges. We're going to go ahead and release you out into the community, and just keep an eye on your mailbox, and we will definitely let you know when the charges are brought. Happens all the time in Arizona. So some of the reasons they do this, as I mentioned, maybe they're consulting an alleged victim. Maybe they're consulting more witnesses on the scene to try to figure out what happened. Oftentimes in these types of cases, there's things that they need to test. Maybe they think, for example, that you are carrying drugs and they have to send it to their crime lab to test it in order to prove that it's drugs. Maybe they have drawn your blood as part of this arrest and they need to send that to their forensics lab in order to be tested. Still another example, many cases, including white-collar cases, fraud cases, things of that nature, certain computer crimes, certain obscenity laws, things like that involve digital evidence. And whenever you're dealing with evidence on a computer or device or digital evidence like that, they need to send that to their forensics lab and have their experts kind of do a data extraction, get access to all of that information first before they can actually bring the charges against you. So bottom line, this happens every day in Arizona where people are arrested but then released, put back out into the community. They say, bye, we'll be letting you know in 7 years, because in Arizona they have a 7-year statute of limitations that they can bring the crime. Now, practically speaking, as we've said in the past, most people are not waiting 7 years to actually be prosecuted for a felony crime. In practice, the prosecutor's offices typically bring it much sooner than that, but they do have the right to keep you dragging along for years. So here's the good news. If you're proactive and if you immediately attempt to obtain a competent attorney, there's often a lot you can do to prepare for the upcoming felony charges. And I want to talk to you today about a few of those things. Now, some of these things that we can help you prepare for when you're waiting for a felony to come, they're more practical things that aren't really legal defenses. For example, we can help you get set up with a bondsman. A bondsman is somebody who, heaven forbid, if you are arrested and taken into custody, they can be standing by to post your bond for you, so that you can get out in a matter of hours rather than a matter of days or weeks, sitting there in a jail cell flipping through the yellow pages, trying to figure out who your bondsman is, how you can show them your assets, try to get them prepared to post for you. It's a giant headache to do from a jail cell. So we like to prepare for a worst case scenario and have a bondsman standing by. We have excellent relationships with many bondsmen in the Valley and beyond in the state of Arizona, and we can definitely get you set up with one ahead of time. Another practical thing we can do is something called a motion to set release conditions, okay? What this is when you're arrested and when they finally do bring the charges, you're going to be put in front of a judge. And that judge is going to look at the facts and he's going to listen to the arguments from both sides. And then that judge is going to set something called release conditions. Okay, in Arizona, release conditions are the rules that apply to you while you're waiting for your case to be brought to trial. So while they're going to release you out into the world and they're going to say, well, your release condition might be that we want you on ankle monitoring, or we want you to have a curfew, or we want you to only go in this area and only go back and forth for work or school or whatever it may be, or we don't want you to go out at all and we want you remanded into custody. There's all kinds of release conditions in Arizona that the court has at its disposal, and some obviously are much more constraining to freedom than others. So what we like to do is we like to prepare ahead of time, something called a motion to set release conditions. This motion is going to do a couple of things. It's going to lay out all the mitigation about you, showing that you are not a danger to the community and you are not a flight risk, because that's the two things that the judge is looking for at your initial appearance to determine what release conditions are appropriate. Now, the standard that the judge has to follow when setting your release conditions is to set the least onerous conditions possible to procure your appearance at trial. So what that tells us is we want to show them two things. You're not a flight risk. How do we do that? We show that you're long established in the community, maybe you work in the community, maybe you have family ties, maybe you have community ties, things of that nature. We want to show that you're well established and not a flight risk to run from this jurisdiction. Number two, we want to show that you are not a danger to the community. How do we do this? Things like mitigation. And for those of you who don't know what that means, mitigation is just the fancy lawyer way of saying the good guy stuff, the stuff that shows that you're a good person. So, for example, lack of criminal priors, the fact that you do community service, the fact that you don't have any historical run-ins with the cops, no histories of violence, strong family ties, things like that. Maybe the nature of the offense itself needs to be contextualized so that the judge can understand that you are not a danger to the community. So we do all of those things with a motion to set release conditions, and it's great to be prepared for that rather than trying to have to figure out what your release conditions are going to be from a jail cell. You'd much rather go in prepared to that situation. Finally, when you hire an attorney ahead of time, this gives us an opportunity to reach out to the prosecutor and the police and let them know that you're represented. Now, what does this do? Well, under Arizona law, this decreases the chances you have of being arrested by the police when the charges are actually brought, okay? This creates what we call a presumption in the law, okay? There's a presumption created at that point and a preference for a summons to be issued to you. So, in other words, if we say, hey, Mr. Prosecutor and hey, Mr. Cop, who are investigating the case, just want to let you know our client is represented. He has retained private counsel. All communication is to go through our office. You're not to show up at his or her house, knock on their door, try to interview them. Now that they know you're represented by counsel, certain constitutional rights are attached. And one of the great parts about this is it creates a preference for a summons rather than arrest. In other words, it creates a preference under the law that they're going to send your attorney a piece of paper called a summons that says, hi, we've charged your client with a crime. Here's their court date. Here's the time. Here's the location. You can hold their hand and walk them in to the court date rather than us beating down their door, kicking it in, going into their house, cuffing them, going through the whole song and dance and dragging them down into the jail. I promise you, having had many clients who have gone through both of these different types of experiences over the year, your preference is for a summons, and that's a preference that's created in the law if you retain an attorney and we reach out to the state on your behalf. Finally, I want to talk to you about something so important that we can do when we reach out to the state, and this has to do with the grand jury proceeding. So one of the ways in Arizona that the state can bring serious felony charges against you is to assemble a grand jury and procure an indictment. Okay, what does that mean? A grand jury is kind of like assembling a regular jury for something like a trial, where you have a random cross-section of the community, they all come together, and then the prosecutor will stand in front of them, usually with the help of a witness, cop, or something like that, an officer of the law who is involved in the investigation of your case. And the prosecutor, through that witness, will present evidence in the form of testimony to the grand jury. And the cop will say, yes, here's what my involvement is in the matter, here's what I saw, here's what the evidence shows, and so on. Now, at these grand jury proceedings, the prosecutor kind of runs the show. There are no rules of evidence that apply here. It's a secret proceeding, meaning the defendant does not get to be present. The defense attorney does not get to be present. Heck, in Arizona, it's even a crime for the prosecutor or any of their staff to reveal to anybody when the secret grand jury hearing is going to be. So it's a very one-sided presentation, and as the old saying goes, any prosecutor worth their salt could get the grand jury to indict a ham sandwich. It's very, very low bar. It's a one-sided presentation where at the end, most of the time, the grand jury decides to indict the defendant. Now, very interestingly though, under Arizona law, there's a mechanism that we can use as defense attorneys to even the odds a little bit here at these grand jury proceedings. And that mechanism comes through something called a Triebus Letter. Okay. In Arizona law, there's a critically important case called State v. Triebus. What that case says is, if we put the state on notice ahead of time of the grand jury presentation of what's called clearly exculpatory information, then the state must present that clearly exculpatory information to the grand jury at the time of the grand jury proceeding. So what do I mean by clearly exculpatory information? Well, in layman's terms, that just means it's stuff that if the average grand juror knew about, would make them less likely to return an indictment. So for example, let's say the prosecutor steps up and presents something to the grand jury. Yes, the defendant in this case punched the victim in the face. An example of clearly exculpatory information in this example would be, but the victim was holding a knife and running at the defendant, right? This is something that if the average juror heard in the story, they'd be like, you know what? It doesn't sound like this person committed assault. In other words, it sounds like their conduct could have been justified under Arizona law. So given the fact that this is a one-sided presentation, unfortunately, sometimes prosecutors don't show both sides of the story. They only show the grand jurors what they want them to hear to procure the indictment, and are not required to show them otherwise unless your attorney puts them on notice of this clearly exculpatory information. So it pays to be proactive in these cases. If you get an attorney early on, we can compose a Triebus letter which fills all kinds of different parts of the story in, could plug in plenty of clearly exculpatory information and demand that it be presented to the grand jury during the grand jury proceeding. And as it turns out, when grand jurors hear the whole story, not just the part that the state wants them to hear, indictment rate tends to go down. And we've had some excellent success with this strategy over the years. But even if you can't get the case remanded after the case is indicted, and what a remand is a judge has now recognized that the state failed to show them clearly exculpatory information that it had knowledge of at the time. And if you can get the judge to agree, then what they'll do is they'll remand the case. They'll say, you know what, prosecutor, you screwed up on the grand jury presentation. You were made aware of this stuff by the defense attorney ahead of time. You had the information. You chose not to present it. I want you to go back and start over the whole process all over again. It's a giant headache for the state. So oftentimes what happens with these grand jury issues is we use it as defense attorneys as another tool in our toolbox when advocating for our clients. What we like to do is file these motions and do what's called hold it in abeyance. Holding it in abeyance is basically we're hitting a pause on the motion. Normally when you file a motion, you see the state has a certain amount of time to file a response and then the judge rules on it. Well, what we like to do oftentimes in these types of cases is file the motion to remand, hold it in abeyance, and then hold it like a hammer over the prosecutor's head, right? So we can go and say, hey, by the way, in addition to all of the defenses in the case and the perhaps Fourth Amendment motions and substantive motions and motions in limine to keep out harmful evidence, in addition to all that, prosecutor, we also think you screwed up on the grand jury presentation. And unless you want to risk the court agreeing with us and forcing you to start the whole thing from scratch, you better give our client a better deal, for example, or you better dismiss this charge or that charge. So bottom line is, this is an important tool in the defense attorney toolbox as an Arizona defense attorney, and you don't want to give it up. You have to preserve it, and the only way to do that is to be proactive early on. Make sure you have done your duty of putting the state on notice of all the clearly exculpatory information before they get a chance to go to that grand jury. Because if they only present what they were aware of at the time and you failed to put them on notice of the clearly exculpatory information, court's going to say, sorry, no harm, no foul. They did everything that they needed to do at the time, and you don't want to let them off that easily. So very, very important to be proactive. If you're arrested for a felony, even if you're not charged yet, the sooner you can get a competent defense attorney, the better. There are so many reasons like the ones I just described, and there's many more reasons as well. So don't hesitate to pick up the phone if you or anyone that you know, a loved one, a friend, a family member, is experiencing these types of issues and is anticipating that felony charges are going to be filed against them. Visit attorneysforfreedom.com. You can call us. The number's down below. There's more information down in the link, and we would love to talk to you about any pending issues that you may have. We're going to start it out by bringing you into the office. We do something very different than most law firms. Most law firms, they'll bring you in, they'll give you the little freebie strategy session where they give you 5-10 minutes, crank you through as quick as possible. We don't do that here. That's not the type of service we provide for our clients. Rather than that, we're going to set aside at least an hour for you to come in, sit down with us, and we're going to get a comprehensive view of exactly what's going on in your case. Not only are we going to listen very intently, we're going to give you full feedback. We're going to talk to you about legal defenses. We're going to talk to you about what court dates look like, what types of tools in our toolbox we can use for you in representing you in your criminal case. So once again, my name is Andy Marcantel, and I'm an attorney and partner at the Attorneys for Freedom law firm. Don't hesitate to reach out if you need anything, and make sure to visit our website for more information. Thank you guys. It's been a pleasure. Have a great day.